So here's a table that shows you the number of, actually it isn't the number of prosecutions, that actually is wrong, it's the number of convictions that we, up to the end of 2009, that we know about in the pale green, almost white actually. And you can see that the United States leads the way, followed by Canada, then Sweden, Austria, Switzerland, France, Norway, as it goes along. But then if you actually look at the number of prosecutions per number of people living with HIV, it looks quite different. So although the US has a high number of prosecutions, because there's over 1 million people with HIV, the per capita ratio is actually quite small. But still, Canada is in the top 10 in terms of being a world leader in terms of both numbers and prosecutions per capita. And you're in good or rather bad company. You know, the US, the Nordic countries, Australia, New Zealand, Austria, Switzerland. Obviously, you can see Bermuda is to the roof, but they only have 200 people living with HIV, and they've already had 5 prosecutions. So here's a framework that I'm going to suggest of how we move forward. We don't just need evidence of where the prosecutions are happening, but we need to know the impacts of these prosecutions, both the intended impacts that the criminal justice system or the lawmakers believe that these laws will have, as well, of course, all the possible harmful unintended impacts. We also need engagement of the key players in the criminal justice system, the police and lawyers and judges, as well, of course, as a community engagement, the community of people living with HIV, the community of the populations most affected by HIV. And of course, we need the general population, and in particular, we need the engagement of the media, who haven't always been very helpful in terms of their reporting, although there are some exceptions, of course, and Extra in particular I'd like to single out as being fantastic, really good in terms of getting it right. We need empowerment. We need to empower people living with HIV. We need to support people living with HIV to be involved in HIV prevention, to shut the stable door before the horse has bolted. And one of the projects that I'm working on with the Global Network of People Living with HIV and UNAIDS is a new paradigm of positive prevention called Positive Health, Dignity and Prevention, which is human rights based and focuses on a shared responsibility for HIV prevention. Of course, we need a lot of effort. It takes a lot of work, a lot of hard work to turn the tide. And I'm really happy to be amongst such luminaries who are doing such a fantastic job here in Canada, where the Courier decision was so disastrous for so many reasons, and you're doing an amazing job trying to deal with this issue here. And we also need education, and that's one of the reasons that I produced this resource. It's an international resource, so it's as relevant here as it is anywhere else in the world. I'm not going to go into it in great detail, but these are the chapter titles. It's available online at aidsmap.com law. You can also purchase a book, which is at the publishers, at the printers right now. There are some flyers somewhere around that give you more information on how to order it. So I'm going to give you an example, some examples of how other countries have dealt with the issue of HIV in terms of how the criminal law looks at HIV as an HIV prevention issue. What's remarkable is way before the Swiss statement that was made a couple of years ago, that I'll explain a little bit more about what that Swiss statement was about in a minute, which looked at the impact of viral load on infectiousness. The Supreme Court of the Netherlands, through a series of rulings in 2004, 2005, actually ruled that in this particular case, which did involve anal sex, that because this person had an undetectable viral load, didn't have any sexually transmitted infections, looked at the type of sex, and which was anal sex and oral sex, and also the frequency. I think so. Maybe 1 or 2 exposures. They found that in this case, that individual was not infectious enough to cause the considerable chance of the charges, which was manslaughter and aggravated assault. So those rulings essentially decriminalized non-intentional HIV exposure and transmission. And the court left it up to the government to decide whether to actually pass an HIV-specific law, which they didn't. And there's only been one prosecution since then, which was an intentional injection prosecution. Now in Switzerland, there is a law that basically criminalizes people with HIV who have unprotected sex, whether or not the person, their partner, has consented, and whether or not, obviously they would have disclosed, and whether or not the partner has consented. In fact, there have been 8 convictions for HIV exposure following disclosure using this law. No complainant is needed. It can just be, if the police find out about it, although it's not clear how the police find out about it, people can be prosecuted. So neither disclosure nor consent is a defense. So there was, in 2008, the Swiss Federal AIDS Commission produced a statement known around the world as the Swiss Statement, that was controversial elsewhere in the world, but was accepted at face value by the Swiss, that someone with an undetectable viral load, with no sexually transmitted infections, who was on successful treatment and under follow-up, the risk of transmission was at least similar to the use of condoms, consistent use of condoms, which they had, the risk was around 1 in 100,000 of transmission. And in this case, there was an appeal to the Geneva Court of Justice in 2009 that was actually called for by the prosecutor who had heard about the Swiss statement. And again, they quashed this conviction because the defendant had an undetectable viral load, had no STI, was under regular follow-up, and had had unprotected vaginal sex a few times, but that wasn't considered risky enough. The prosecutor, in an interview subsequently, said one shouldn't convict people for hypothetical risks. And I think we can learn some good lessons for Canada here. I'm just going to go very briefly into what we've done in England and Wales, which hopefully is very relevant to what's happening, what is going to be launched tonight, in terms of how we've managed to mitigate the harm of the law in England and Wales through prosecution guidelines and also police guidelines, which both of which were a struggle to produce. They took over 2 years, involved a lot of civil society engagement. And in fact, the first draft of the prosecution guidelines were horrendous, but they were critiqued by all the experts involved in HIV, as well as civil society, and what we have now produced has limited prosecutions. Now in England, it's only transmission that can be prosecuted, and so these guidelines have focused particularly on the importance of the limitations of scientific evidence to prove transmission. And quite a few cases have been dropped, many haven't moved forward. So these have clarified the law, reduced court cases, and really helped on both sides, the criminal justice system and the HIV sector, in terms of mutual understanding. I don't have time to go into great details about the police guidance, but if you look at the link below, the www.nat.org.uk, this is where the police guidance is available. There's a whole load of documents that have been produced to help the police understand HIV, understand what the law says, and to deal consistently and and respect the confidentiality of complainants and of the accused during the process.